Welcome to the Judicial Branch Family Services informational session video for parents involved with the Connecticut Family Court System. If you or the other parent are considering filing or have filed for a divorce or for custody and visitation, this presentation will provide you with a basic overview of the court process regarding child custody and access. Family Services is a judicial branch department whose staff of family relations counselors are here to assist you and the court in helping to resolve your family's concerns and issues. Our goal at Family Services is to help you access resources right at the start and to help you to be better prepared to navigate the court process. We want to help you to reach agreements and to keep your children out of any conflict. Please do understand that this presentation does not provide you with legal advice. You always have the right to seek legal advice from an attorney. However, please note that if you represent yourself, you are still required to follow the same procedures as attorneys. Whether you have an attorney or are self-represented, there are resources to help you. There are court service centers in most courthouses. You should check the judicial website or contact the court in your judicial district to find current hours and staff availability. The service centers have workspace available and offer computers, printers, copiers, and scanners, as well as fax and phone access. Court forms and information on judicial publications are available, as well as electronic or e-filing service assistance and notary public services. Online, the Judicial Branch website provides many resources. The Family Case Lookup page allows you to find your case, check general information, and register for email alerts for notification of upcoming court dates. You can find information on access to virtual, remote hearings, and you can find forms online. One of the most important forms is the Financial Affidavit. You must complete a financial affidavit for any child support or financial issues to be properly addressed by the court. You can download the Financial Affidavit and should fill it out prior to your court appointment. You may want legal advice to help you complete the affidavit. Before it is filed with the court, you must bring the affidavit to a notary or officer of the court and sign and swear to it in that person's presence so that it can be notarized. Also, for the affidavit to be current, please make sure that the affidavit is notarized within 30 days of filing it. Besides forms, there are many other resources on the judicial website. In addition to answers to frequently asked questions, there are step-by-step resources, self-help legal guides, numerous judicial publications, and information on our law libraries. Before we go through the court process in more detail, one of the requirements of any Connecticut divorce or custody action involving children under the age of 18 is that the parents participate in the parenting education program. There is a fee. The program's classes provide detailed, age-specific information on the issues children face when family situations change, so that you can help them adjust according to their needs. The classes also provide support for conflict management, cooperative parenting, and stress reduction. Multiple providers are available statewide. Please note that there are community-based services available for free should domestic abuse be a concern during your family court process. Signs of an abusive relationship can involve a partner controlling finances, daily activities, your use of the phone or computer, a partner belittling or embarrassing you in front of others, a partner threatening violence against you, your children, or your pets. If you would like additional information or someone to talk to from a resource independent from the judicial branch, please consider contacting a Connecticut-based advocacy resource as provided here. And now for information on the court process itself. If children are involved in your court process, your priority is putting their best interests before anything else. It is also the judge's priority. It is important to focus on working with the other parent to meet the children's needs, focusing on the children's needs instead of your own interests. Parents can have different views on what is best. When you and the other parent cannot agree, a judge will have a family relations counselor from Family Services work with you on your parenting plan. Our goal is to be respectful to your role with your children and your strengths, and not be more involved than is needed to help you resolve your dispute. If disagreement continues, a judge will decide what is in the best interest of the children. Whatever may end up being needed during the court process, please avoid exposing your children to parental and court conflict. Family Services and family court staff want to support your co-parenting efforts and help you through this, but we need your active participation in cooperative effort. Absent court orders or domestic violence, it is expected that both parents will work towards a cooperative parenting relationship. However, please also give yourself time to adjust to the changes taking place in your family. Try to be as patient with the other parent as you are with yourself. Communicate as best as you can. If there are words that upset you, pause, give yourself a break, and reflect before responding. Here are some suggestions for positive communication. Keep communication short and to the point. Avoid negative comments. Just state the facts. Be clear about what you are requesting. Have reasonable expectations and state them simply. Apologize when you make a mistake. We all make them. Finally, don't miss out on opportunities to be positive, supporting, forgiving, or thankful. And please, do not use your children as messengers of information or involve them in decision-making. Do not ask your children to choose between you and the other parent. And please, do not speak negatively of the other parent in the presence of the children. In working together as parents during the court process, your first encounter with family relations counselors may involve a screening with Family Services. This screening involves an initial meeting with a family relations counselor to discuss the issues in your case and determine the track of court involvement that will best help you. At the conclusion of the meeting, you will have an established point of contact with Family Services for your court process, as well as recommendations for your case's direction going forward to resolution. Recommendations from the Family Relations Counselor need to be ordered by a judge prior to services starting. Service recommendations can include the following, which are explained in detail in other materials available from the Judicial Branch. Negotiation services through case date conference, pretrial, settlement conference, or agreement review. The Early Intervention Program. General Case Management. Mediation. The Conflict Resolution Conference. Evaluative services, such as issue-focused evaluation or comprehensive evaluation, and intensive case management. It may be helpful at this point to go over several commonly held misconceptions about family court. You may have heard this statement, "I want full custody." Full custody is not a legal term in Connecticut. There are two kinds of custody, legal custody and physical custody. With legal custody, there is joint legal custody and sole legal custody. Joint legal custody means that both parents make major life decisions about their children together. Major life decisions include choices involving education, religion, and health. It is generally accepted that it is in the children's best interest to have two informed parents involved in their major life decisions. Sole legal custody means that one parent makes these decisions. Physical custody, often referred to as primary residence, indicates the parent with whom the children primarily reside. If two parents are able to coordinate having substantially balanced residential and day-to-day parental responsibilities, including the obligation to take children to appointments and activities, and to care for them in the home when they are sick or not otherwise in school or daycare, the court may consider an agreement of shared physical custody with an agreement on school choice also being specified. You may have heard this statement, "I want 50-50 custody." There are 7 days in a week. There are a variable number of days in a month, and usually an odd number of days in a year. Parents often have to work, and children have school and activities. Parenting plans are not math problems. The quality of time with a child is far more important than the amount of time. As mentioned, there can be an agreement involving shared physical custody, but considerations for this arrangement include many factors such as the children's schedules and activities, how far apart are the parents' homes, and what is in the children's best interest. I don't want to talk. I just want to see the judge. While it's understandable that you may want closure, and so may the other party, it is best to talk with Family Services as part of the process. This does not forego talking with the judge or presenting information at a hearing. However, time and time again, we have seen parties come to an agreement through the use of Family Services. When parents successfully negotiate a parenting plan, they have control over the decisions that impact their family. There may be other options prior to seeing the judge. You may have heard something like this statement: shared custody means no one has to pay child support. This is wrong. The court considers many factors when determining child support, including the differences in the parents' earnings, and few parents have exactly the same income. Even if parents with similar incomes share time with their children in roughly equal amounts, a child support order is still likely, and expenses for health care and daycare have to be considered as well. You may have heard or even found yourself saying some combination of these words. My friends, my neighbors, my cousins said that when they went to court. Many people will readily share their family court experience with others. Every family and child's needs are unique. Just because one family had a specific result, it does not mean the outcome will be the same for your family. Family Services will provide you with information and recommendations for your family's situation and court process. The last misconception we'll go over concerns bringing children to talk to the judge. Typically, the judge does not speak with children. Instead, the judge may rely on a court-ordered family relations counselor, a guardian ad litem, or an attorney for the minor child to speak with the children when needed. Even older children should not be placed in the middle of a parental dispute. Family Services does not ask children to make decisions on custody or parenting time. This concludes this presentation. If you have further questions, please contact your local Family Services office or Court Service Center. We hope this presentation has been helpful and wish the best for you and your family. Thank you.